Hello viewers, happy to meet you through this presentation. In this video, we are going to learn what is a constitutional remedy and what are the remedies we could find in our constitution. So in this video, you will be learning certain things in detail. So the first question which we are going to answer is what is a constitutional remedy and what is a writ and history of writs, type of writs, and what is appeal. So, let us start from this question to make you understand very simply what is a constitutional remedy. Let us split this into two. One is constitutional and another one is remedy. Remedy, which means a solution. Constitution, what is constitution? It's a set of rules stipulated by the government for the people, in fact by the people. So rules must be followed, and in certain times you cannot follow certain rules, and there are some possible ways. In some way you should help people, those who are having a particular issue. To make you understand very simply, we should follow the traffic rules. When I wait for the signal, traffic signal, for ambulance, it is something different. Likewise, in certain cases, everyone may not be in the position to follow certain rules. So, while preparing this constitution, the committee has given certain remedies, which means solutions. In case if you cannot follow, or in certain circumstances, if you come across certain circumstances, what you could do. So for this, there is a solution for everything. So likewise, any right is meaningless, as it says, without remedy for its enforcement. So, fundamental rights. So, we have fundamental rights for every citizen. You got your own rights, and based on your rights, you can enjoy your liberty and you can enjoy your freedom in the society. And in case of violation of any fundamental rights, one can move to the Supreme Court, the predominantal authority, and you can state and you can express your difficulties to the Supreme Court, where you will be given a solution for the problem. And this is right, and it is also available in two different articles. They have discussed in two different articles. One is given in part 3, Constitution part 3, and we are discussing the constitutional remedies in two different articles, that is Article 32 and Article 226. And what is a constitutional remedy? According to Dr. B.R. Ambedkar, he says it is the very soul of the constitution and the very heart of it. Why? Because there must be someone to help the needy or the suffering person must be directed, and he must be or she must be addressed. That's what he says. The right to the constitutional remedy was created as one of the main rights, because if there is any possible way, or if there is any difficulties, I must be addressed by someone, or someone must come to save, rescue the sufferer. So, in case of rights denied, so we have our fundamental rights. In case if my fundamental rights are denied, what are the rights? as it goes: right to equality, right to freedom, right against exploitation, right to freedom of religion, okay, cultural and educational rights. If anything is denied or deprived, citizens can approach the Supreme Court. It is not only the Supreme Court, including high courts or any local courts, but this will be well addressed by the Supreme Court and as well as the High Court. And here we would like to learn in detail what is this? The distinction between Article 32 and 226, where there are certain guidelines given in our constitution to have those remedies. So, Article 32 and Article 226. So, what it talks about? Article 32 can be exercised for the enforcement of fundamental rights only. But Article 226 can be exercised not only for the enforcement of fundamental rights but also for the enforcement of rights other than fundamental rights. This is very, very important. So, Article 32 talks only about fundamental rights, and Article 226 it talks about fundamental rights, but also it talks about other rights. We have other rights too, and it has to be given, and you must enjoy those rights. In case if it is denied or deprived, you can use certain articles and you can approach the Supreme Court as well as the High Court, and you will get some justice. That's what we are learning from this idea, this slide. And the most importantly, we are going to talk about Article 32, guaranteed effective and cost effective remedy for the protection of fundamental rights. At the same time, Article 32 establishes the Supreme Court as the protector and insurer of fundamental rights. As how we call the Supreme Court as the guardian of Indian Constitution, they are also the guardian for helping to have or enjoy your fundamental rights. This means that rather than appealing, a person can contact Supreme Court directly for a remedy. So any citizen, in case if I feel my freedom, my liberty is denied, or if there is any problem, barrier, I can approach the Supreme Court as well as the High Court. And under Article 139, the Supreme Court enforces the rights of other fundamental rights. Please make a note of it. And the High Court, the superior courts of the state, may issue writs under Article 226. So, Supreme Court issues writ under Article 32, which focuses only on the fundamental rights. Article 226, which focuses on fundamental rights as well as other rights of any individual, especially the citizens of this country. And it is not possible, even though Supreme Court or High Court can help you to get some solutions or remedies in case of in difficult status. In certain period or time, you may not get the remedies, especially during emergency. Even Supreme Court as well as the High Court may say no, even though you appeal. Why? Because during national emergency, the government has the flexibility to upend the rights of any citizen. During that time, you cannot say, I have freedom of speech, I have freedom to do anything as I wish because I am the citizen of this country as well. You cannot claim. Why? Because the emergency is announced in certain countries. Now you may take China as an example. Chinese people are quarantined and they do have their own rights. Even then, during the period of emergency, even in our country, you have seen such certain things during the lockdown where your rights are cancelled and you cannot claim for your rights because it's an emergency, medical emergency, financial emergency. So likewise, national wide emergency, state emergency, whatever it may be, that would be very difficult for you to claim. And according to Article 32, Indian citizens can stand up and fight for their fundamental rights if they are breached. It is there, but it is not possible during emergency. That you must understand. So there are possible ways where a government can control their citizens, and this is the finest remedy. What is the remedy? This is the remedy. So writ is an remedy. So we need to learn what is a writ. Usually it's a formal order in writing issued under seal in the name of a sovereign government, court, or other authority, commanding an officer or other person to whom it is issued to do or refrain from doing some act specified therein. So writ is a key. Writ is a key to protect people, especially when they have been stopped by the government. Especially, you must learn things clearly. When the government stops you, when your local authorities are stopping you from getting or doing something, you can approach the court, where the court will ask the government or ask the authority to set you free and act with the liberty. So that's what writ. So writ is just a formal order, especially that comes with the seal, which means it is official. It's an order from the court that we must understand very clearly here. And the most importantly, Article 32. What Article 32 talks about here? The remedies for enforcement of rights conferred by the spot. The rights to move the Supreme Court by appropriate proceedings for the enforcement of the right conferred by the part is guaranteed here. So through writ is issued by the Supreme Court, by the High Court. Here it is based on Article 32, we have already seen, and according to Article 226, it is being issued. And the Supreme Court shall have power to issue directions or orders or writs, whichever may be appropriate for the enforcement of any the rights. So they may issue an order or they may direct the people in cases. They issue a writ, which is more important. As you see, if it is issued by the Supreme Court or by the High Court, whatever it may be, that is very, very effective, very powerful. But writ is more powerful because that comes with a seal. That is very, very important, that we must note it down. And here, history of writs in India. So when we started, how we started, that is the story that you need to learn, and by whom it was issued first. The first writ was issued by the Supreme Court of Calcutta. So I think you may aware there were three Supreme Courts during the British Raj. After that, only we have abolished two, and we have only one now at present in Delhi. So the first issued by the Supreme Court at Kolkata, and later by the Supreme Courts of Bombay and Madras. And from 1861, the writs are issued by the high courts, and since 1937, federal courts of India. So, likewise, we started the history that comes from the while how they started and why they have started. As we already stated, this writ that helps to protect people when the government or authorities are blocking them from getting their desired wants or their fundamental rights. So, in case the government stops, or if any authority, government official, if they stop, there comes the High Court and Supreme Court into the picture to protect any citizen of this country. The next one, written Indian Constitution in detail as per Article 32 and Article 226 of the Constitution, the Supreme Court and the High Court can issue the writ to the government and to any individual. The individual here, what we mean to the officials, those who are working under the government in the government office. And kinds of writs. What do you mean by kinds of writs? We have different kinds, types of writs. So we have totally five. So what is a writ? A writ is a document, official document that comes with a sign and seal. So we have five different writs here. The first one is habeas corpus. The second one is qua warranto. The third one is mandamus. Then fourth one is certiorari, and fifth one is prohibition. So five different writs are issued on different circumstances. So we will be learning writs in detail in the next lecture, and this is the finest solution. So this is an introduction, and this is the solution how you can get help from the Supreme Court or High Court when your rights are denied or deprived. And the next one is the most important idea here is public interest legislation. What do you mean by PIL? We call that the shortest form of public interest legislation is PIL. PIL, which means the legislation filed in a court of law for the protection of public interest. The most important is if you have, or if you are filing a case against the government or any official, in case if the government is depriving, if they are against law or constitution, any individual, any citizen can file a case. And this bill, what it talks about, it talks about the public interest such as pollution, terrorism, road safety, constructional hazards, etc. Any matter where the interest of public at large is affected can be redressed by filling a bill in a court of law. So if most of the people, for example, if hardly 100 families, 200 families, if they will suffer because of the action taken by the government, you can file a case. That is called a public interest legislation. So this is a very important key. For an individual, it is writ. When you feel that my freedom, my liberty is having, no, I cannot enjoy my freedom, you can approach the Supreme Court, you can approach the High Court. In case if the entire village, or if the entire town, or if the entire street people have some problem, they all together, based on the public interest, they can file a case. And we have given the circumstances. What are the circumstances? We have very few. So we have pollution issues, terrorism issues, and safety and constructional hazards. Likewise, if you have any such things, you can approach the government and you can get your remedies. So, constitutional remedy, it is for any individual, that you must remember. So, individual can approach the court when the government is forcing, or any government official, if they are forcing an individual, helpless individual, those individuals can approach, and the Supreme Court as well as the High Court will take care of the particular individual, and they will see to that the justice is given to that particular person who brought the issue under the limelight. That's what we have learned. So, here, altogether, overall, what we have learned from this lecture, what is that writ? So, mostly when it is being issued, as we already stated, when you have problem, when an individual is facing a problem, the writ is issued. So, powerful orders. So, what are the powerful orders? We have two. One is writ and another one is pill. And pill is issued. When it is issued, when the public, or when the public is facing certain issues, you can go and approach. And major works of high courts lies in exercising writ jurisdiction. So, high court, as we already seen, Supreme Court ensures only the fundamental rights, and the high court that ensures fundamental rights with other rights too. So, this is what we have learned. In our next lecture, we are going to learn the types of writs in detail and other benefits in favor of how citizen can approach the courts, and how the courts are helping people, and how they are putting a barrier, or how they are restricting the government, or how they are controlling the government official if they go against the law. Thank you. Hope you enjoyed my video. I request you people to subscribe and share this video to your friends and family. Have a nice day. Jai Hind.